my mother would ask me whenever I would tell her that I'm representing someone, the first question she would ask would be, is he innocent? And then when I would tell my mother what the charges were, she would then ask, how can you represent that person? Now imagine multiplying that by the hundreds of thousands or even millions. Because when we're talking about mass atrocities, we're talking about events where hundreds of thousands of people may have suffered in one way or another. The challenge in being a defense lawyer in these sorts of cases is, as my colleague Angel Dong indicated, first and foremost is having sufficient skills and knowledge in order to undertake the representation of someone. You also need a very large team, and you need resources. This case is fairly large. The one that I just finished, it took 5 years for the trial. The record, just what we spoke in court, was 52,000 pages long. There were hundreds of thousands of documents. And at the end of the trial, we were given approximately 1 month to summarize all of the events, all of the documents, all that was said in court in less than 200 pages. And after that, we were given 4 hours to give an oral argument, a final argument. It's an impossible task. As Mr. Angodong indicated, the truth is something that you're not likely to find in the courtroom. Some think that going to court in a case such as this one, where we will find the historical truth about the events that occurred in Cambodia. The fact is that you will never find the historical truth because there are lots of limitations imposed on the court itself before you even begin to hear the evidence. First of all, in this particular court, the jurisdiction of the court is only from 75 to 79, as if nothing happened prior to 17 April 1975, or nothing happened after January 8 or 9, 1979. No historical context, in other words, as if the carpet bombing by the U.S. or the involvement of the Chinese or others had nothing to do with any of the events. Also, governments don't cooperate. It is unlikely to get a government like the United States to share its archives, or China, or Russia, Soviet Union back then. They're simply not going to provide you with access to the documents that you might need because they have issues of their own. Not that they are necessarily worried about being implicated, but for national security reasons. And that's happening in every single tribunal, not just this one, but in others as well. So you never have access to all the information. You will never have access to all of the witnesses. And in this particular case, because of the system that you have here, the defense are not entitled to do their own investigation, which places a lot of limitations on the lawyers. What a tribunal can do, and what lawyers can assist in, is that certain facts, certain historical facts, can be proved beyond a doubt. And that's important. It gets you further to the truth. But being able to establish that a certain event occurred, and where it occurred, and who was responsible, and what happened, that is possible in a court. The challenges for the defense lawyer in these sorts of cases is, first of all, the entire system is against you. Everyone already has convicted your client in the court of the media, that is, in the public arena. They've already convicted your client. He is there, therefore he's guilty. He held a particular position, and therefore he must be guilty. And one of the challenges that we face is trying to get a little breathing space so that the facts, when they're heard in the courtroom, can breathe and tell the story. It is not our job to prove anything. That job is for the prosecutors and ultimately for the judges to determine whether there are facts sufficient, the evidence sufficient to prove the charges beyond a doubt or beyond a reasonable doubt. But our job is to file motions, for instance, to challenge whether what is being charged was a crime at the time. In this particular tribunal, one of the challenges that we face is that the events occurred a very long time ago. And so, one of the biggest issues from the legal standpoint is what was the existing law, the international, customary international law, during the relevant period of the indictment, that is from 75 to 79. What it is today, in many instances, we know. We know because we've had this tribunal for the former Yugoslavia operating since 93, basically. And so they've accumulated a great deal of knowledge over the years and determined what the law, the international law is for the period of those events, which would have been 91, 92, 93, 94. But prior to the establishment of the tribunal for Yugoslavia, and then for Rwanda, Sierra Leone, and what have you, with the International Criminal Court, the only frame of reference that existed as far as a court was in Nuremberg and in Tokyo. And so you had a big gap. And the question is, what is the law, or what was the law between 75 and 79? Because only that law can be applied in determining whether certain events are crimes. Whether, for instance, you have this concept known as joint criminal enterprise. That's something that was created in the Yugoslavian tribunal. The question was, before this court, did it exist back then? So from the legal standpoint, there are all these issues that have to be determined. Factually, you also have a tremendous challenge. Even if you did have the opportunity and the right to investigate, the events happened so long ago that it's very difficult to track down people. It is difficult to get a proper narrative from the witnesses as to what exactly happened back then. Not what they learned afterwards, what they may have read in the newspapers or in books that were written by journalists, or political scientists, or historians, or what they heard on television, but what actually they knew at the time. As we're speaking, there's a case going on before the International Criminal Court. This is the permanent one, on events that occurred a few years ago, 2 or 3 years ago, in Kenya. those events are very fresh. It's very easy to go to the scene where an incident, a crime occurred. It's easy to track down the witnesses. Now, whether the witnesses will speak or not, that's a different story. But it's much easier to find the documents. You come over here, 30 years have gone by. The witnesses, some have died, some are too old, some don't remember, or some have faulty memories. Faulty in the sense that they learned information afterwards. So while they may have information, it is unreliable. And so I bring this distinction of the two cases so you can see that when you come to Cambodia in this particular court, there are tremendous challenges for the defense. The system that was adopted here allows the trial chamber, the judges, to determine who the witnesses will be. In other courts, the prosecution decides its witnesses, the defense decides its witnesses. Here it's the court. But the challenge for the court is they have to read all the documents that are in the file. You're talking about thousands and thousands of pages of documents. And from there they need to make a determination as to which documents should be admitted and which witnesses they should call. One of the challenges I see at trial is where you call somebody who comes from a distant part, from Phnom Penh, some village. They come here. They haven't met a lawyer. They haven't met the prosecutor. Maybe they spoke with the investigative judge. And now they're asked to take an oath and begin answering questions about an event, being shown documents that they haven't seen. And the challenge for the lawyer is, how do you question this individual? The same thing goes for the prosecutor. So in a sense, we have a lot more challenges here than you would in other tribunals, but no matter where you go, representing cases where mass atrocities have occurred are challenging because it's not a question of whether the events occurred, but they're so widespread or systematic in some places. There's so much information out there. It is so difficult to figure out who was responsible and at what level, that it's not a matter of determining whether a crime was committed, but who was responsible. And when you're representing individuals at a very, very high level, the biggest question always is going to be, did that individual at that very high position have any responsibility relating to this particular crime that may have occurred? First, they have to prove that the crime occurred. Then they have to prove that who is responsible, who actually did it, and then move up the chain to see whether the person who's actually sitting in the dock, the accused, whether that person is responsible. Either he had a relationship that went all the way down to the person who committed the crime, or there was some sort of a horizontal relationship where he was engaged with others in some sort of a plan for those crimes to be committed. So even though he may not have responsibility over that individual, they would have responsibility over the conduct of that individual because of that horizontal relationship. The other challenge is, of course, these cases take a very, very long time to try. As I indicated, my last case, we were in court for 5 years. So think back what you were doing 5 years ago, and you can begin to conceptualize that time. This case is going to take 2 or 3 years to try, maybe even longer. And one of the challenges for the court, if not for the lawyers as well, is the overwhelming pressure that is being placed on the parties, that is, the prosecution, the defense, the civil parties in this instance, to move the case as quickly as possible. Because the longer it takes, the more impatient the public becomes. And of course, since these institutions rely on foreign money, donations from other countries, when things move slowly, the donors lose patience and lose interest. It's as if the attitude is, let's have a quick trial, find them guilty, so then we can move on to the next place. That's how it feels from the defense side. In any event, I hope these remarks were helpful. I was trying to supplement some of the remarks made by Mr. Rodon. And if you have any questions, I'm sure he will be able to answer them. If not, I'll be happy to answer any questions you may have. Thank you very much.